Sierra with the Florida Small Business Legal Center. This is episode number 44 of Business SOS podcast. Thank you for listening. I'd like you to participate in the show. If you have a legal question that you'd like me to address in the show, please send me an email at richsierra.com. And if I select your question, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Throughout my podcast, my theme has been make sure you get an attorney before you get into any type of legal matter, whether it's a contract dispute, certainly a lawsuit, because it is very difficult to understand legal concepts unless you're an attorney. And the premise of my book, Business SOS, is that many of the common mistakes that business owners make, legal mistakes that business owners make, is that business owners tend to want to resolve things themselves and they want to do it without an attorney. Then when they do it, they end up in more difficult situations by the time they come to my office and for me to try to unravel what they try to fix. So I've been talking about that for pretty much close to a year now. Today, I'm going to do something a little different. This is the only time that I will tell you can do something yourself. Today, we're going to talk about small claims. And the topic is going to be, I'd like to file a small claims lawsuit. What should I do? So if you're a business owner and typically if you're going to file a lawsuit in county court, anything over $15,000 or more, you will have to get an attorney, or you get sued for anything above small claims, you'll need to get an attorney. So let's talk about what is small claims and the jurisdiction first. Small claims is like the people's court. If I was going to give you an analogy, in Florida, the maximum jurisdictional amount for a small claim is $8,000. So anything do you have, if you get sued for anything less than $8,000, most likely will fall into small claims. If you have say a customer has not paid his or her bills, and you need to sue someone for a claim up to $8,000, that will fall into small claims. And for that, you do not need an attorney. You can actually, as a corporate representative, you can represent your company in a small claims matter. That is the only exception. Still, you got to have some caveats here. I'm not saying that you should always represent yourself. The rule is if you're being sued by an attorney, you might need an attorney to represent you in this matter, simply because the attorney knows the rules of court and you don't. If you're being sued by an individual, in small claims, for the most part, you can probably handle it yourself. So let's talk about the process of small claims and where to file. So I'm getting this information, and I'm going to post a link to their website. This is the Self-Service Center in the Palm Beach County Circuit Court. I'll be putting a link in our show notes to the clerk of the court's website, and it has a self-service center with forms and videos, and you'll be able to, take a look at that if you want to. But also, in pretty much all jurisdictions, all circuits in the state of Florida, when you go to the clerk's website, there will be a section on self-help, self-service center, or small claims forms. There'll be a section for that. You can download those forms. The forms are pretty similar throughout different circuits. We practice primarily in Broward, Miami-Dade, Palm Beach, and we also Orlando as well. So we're familiar with those forms, but they're pretty much the same. Or very similar. So what do you do to go to small claims courts? First, you go to the website and download the form. And you got to read. There's a lot of forms you got to fill out. You got to read them very carefully, okay? They're not difficult, but there are steps you got to follow in order to make sure that you do it correctly. So the first thing you need to find out is how much it's going to cost you to file small claims. And in this court, in this, I'm sure this is the state of Florida as well, there's different rates for different types of claims. So, for example, if you have a claim that is less than $100, I truly do not recommend filing small claims for less than $100 because it's going to cost you $55 plus service of process, you're going to end up spending more than the actual claim. But just for the sake of explaining what the rate system is, claims less than $100 to $55. Claims between $101 and $500, $80. Claims between $501 and $2,500, it's $175. Claims between $2,501 and $8,000 is $300. So you got to make the calculation how much it's going to cost me to file the claim in small claims versus what I'm going to get in return. But that's the filing fees. Summons, it'll be $10 per defendant. If you want to have the sheriff's office serve that summons and the statement of claim, which I'm going to talk about shortly, on your behalf, is $40. That's paid directly to the Palm Beach, in this case, Palm Beach County Sheriff's Office. Or you can actually hire a private process server to do it for you. It'll probably be more. In my experience, process servers go between $65 and $100, depending where you're going to serve those documents. Okay. Where should you file your case? And this is very important because now we're dealing with people living in different counties, people different states. So where should you file it? So, and that goes into jurisdiction and venue. One of the things you need to know is where, if you have a contract, where the contract was entered into is one of the areas where you can actually file to have the proper venue. Venue means which county will you be filing this lawsuit. Jurisdiction is what court has jurisdiction over the case. And I know I'm going here in a deep dive a little bit more into more technical areas so that I usually speak with, but it's important to understand that distinction. So where the contract was entered into is an area that you can actually file the lawsuit. If the suit is for an unsecured promissory note, where the note is signed or where the maker resides. Maker is the person who actually signs the promissory note, who's going to be paying that money to the lender. If the suit is to recover property or to foreclose on a lien, where the property is located at. Another area where you can actually file is where the event giving rise to the suit occurred. Where any or more of the defendant's suit resides, and any location that was agreed upon in the contract. And if there's an action or a lawsuit for that is money owed to you, if there's no agreement as to where the suit may be filed, where the payment is going to be made. So those are areas and that is important to understand to sue in the proper place. One thing is that you, as the one that is suing, you cannot just sue in your county if it doesn't meet these criteria just because it's convenient for you. Because what's going to happen if you file in the wrong county, in the wrong court, you're going to have a challenge as to the proper venue to bring the lawsuit, and you might not even get to the facts because if you don't sue in the right county or you sue in the wrong court, it's not going to go anywhere. You basically end up back to square one, and the lawsuit could get dismissed. Okay. So the next step, once you determine the amount, whether you decided to file the lawsuit, you're going to go ahead and file the lawsuit. Say the claim is $8,000 for sake of this conversation. And frankly, my recommendation that if you're going to take the time and effort to file a lawsuit in small claims, you got to weigh, again, what I said before, how much it's going to cost you versus how much you're going to get in return or could get in return. So the next step is for you to prepare the statement of claim. The statement of claim is equivalent to what we call the complaint in circuit court and county court. It's a one-page document that you fill out. And for those who are watching me in YouTube, it's a one-page document. I just briefly showed it. And it's part of the small claims package. So when you go to the courthouse, say you want to go to Palm Beach and you want to file it in Palm Beach County, you can go to the website, self-service center. You can buy the package for $5. And in this case, some other courts provide it for free. And the package is there. You can download it, and you can go ahead and and begin the process. I do not know whether you can actually go to the courthouse and get it for free. I presume that you can. They might have a section that you can go and get the forms for free if you go to the courthouse. So obviously, it is basically a fill in the blanks form, and fill in your name as a plaintiff, the defendant, the address of the defendant, and then you got to show what you're going to be suing for. And I'll give you a number of options. Whether it's an auto accident occurring in the vicinity, and you don't see too many of these because usually insurance handles that. So I'm not going to talk too much about suing for auto accidents, but there's a section here that if somebody hits you and you want to sue them for less than $8,000, you can do it in small claims. For goods sold by the plaintiff, goods and prices and credit listed below means that you sold something and people did not pay you. And if it's less than $8,000, you can file it in small claims. For work done, materials furnished, time and materials, showing the charges and credits listed below. So you did some work for someone, whether it's a contract work, whether it's a work at somebody's property, and that's a different conversation regarding liens, but I'm not going to go into that at this point. You did work for someone, you did not get paid. The claim is less than $8,000. You can file it in small claims. You check off the box, and that's just the proper section. Another option you have is money lent to the defendant on blank date with interest owed since blank date. Now, I want to talk about this a little bit. So you have something called statute of limitations, and that's not something that is addressed in the forms. Florida law on claims that are based on a contract, you have a 5-year statute of limitation, meaning from the time that it was breached. So you're on a written contract. So you have a written contract, it was breached, you can file the lawsuit within 5 years from the day that it was breached. If it's anything else, if it's money lent, say oral agreement, verbal agreement, or any other claims that is not a written contract, then you have a 4-year statute of limitations. And I'm talking in the context of civil litigation. There are other areas that have a shorter statute of limitation. I'll give you an example. I believe medical malpractice has a shorter statute of limitation, or professional liability has a 2-year statute of limitation. So it's important to understand, what is the limitation period for filing a lawsuit. If your claim deals with money, written contract, 5 years. If it's something else, or maybe deals with money that is owed to you, but it's not based on a written contract, you have 4-year statute of limitation. My suggestion is don't wait to the end, because the information gets stale, the witnesses are not available, so on and so forth. So just want to make sure that you understand that trigger. When I saw the word since, it's important because if you have here a date, say that since 2019, for example, the money was owed to you and you filed a lawsuit in 2024 and it was not a written contract, you might have been outside of statute of limitation, which will preclude you from pursuing the claim. It's important to know that. A promissory note, that's a written document. So you have 5 years, executed on blank date. The copy of the promissory note has to be attached to the statement of claim. The defendant failed to either pay the note on installment or payment and interest owed since blank date plus attorney's fees. Obviously, if an attorney's filing this, you can collect attorney's fees. If you don't, if you do it yourself, you're not going to collect attorney's fees in this one. Another one is account stated, for an agreed balance owed on business transactions between the parties. The defendant did not object to the statement account presented, and a copy is attached. It's a statement that is given to your business owner. You send a statement. It's not objected to. It's not paid. That's what is called account stated. And you can sue on that in small claims. Again, you as a business owners can do this yourself. It's always recommended to get an attorney, but you're not required to have an attorney to file a claim in small claims for invoices or for money that is owed to you less than $8,000. and any other claim, and you got to specify. There's a section here, explain below the details, what happened, dates, times, place, etc. your claim. This section must be completed. Attach additional pages if necessary. My recommendation is you have, say, put C attached. On that section, it's only give you like 4 spaces, and just include a typewritten document in the back of the statement of claim as an attachment or an exhibit to the statement of claim to have clarity in your lawsuit. If it's a copy of the contract, that has to be attached. If a copy of the promissory note, that has to be attached. But the more explanation you have here on the lawsuit, the better for you. Then obviously you write, wherefore the plaintiff demands judgment the principal amount of blank, say $1,000 plus cost if known. You put the cost that you paid, in this case will be $510, and then plus interest. If there's an interest that is owed to you, you write it here in this section, and then you write the total. You sign it, you print the date, and your name, you put your address, your telephone number, email address. So this is the statement of claim, and that's the first thing you have to do. Once you file the statement, you go to the courthouse. You can do personally go to the courthouse and file a statement of claim, pay the fees, or you could do it online. If you want to do it online, my recommendation is they have a video that you can watch. They have a guide that you can download and read and understand how to file, e-file, what we call it, something with the court. Because if you don't do it correctly, it's just going to get rejected all the time. And we file items every day in our practice. We do have a high litigation volume practice. And sometimes we make mistakes, things get rejected. It only means that you have 5 days to fix it. You go submit, it could be a typo, could be a wrong title, things happen. So, and we do this every single day. Can you imagine if you have never done this before, and you don't read the guide, you don't follow the instructions, you're going to make a mistake, you're going to get frustrated because you're trying to file something online and it gets rejected. So just read the form and get familiar with the process. So you file a statement of claim, and you pay the summons. You want the sheriff to serve the complaint, the statement of claim to the defendant. So the clerk is going to create a notice of a pretrial conference. And this is what is different in small claims from county court and circuit court. So they're going to have a notice of pretrial conference in which they're going to have a date already established, usually within 60 days, 50 or 60 days from the time that you file, in which you're going to have already a hearing with the judge right within, 50 days. And so that's going to be set already by the clerk. Then that information, that summons with the pretrial conference, is going to go to the sheriff's office. They're going to serve this to the defendant, to the person you're suing, and they have to show up. You're going to get back either return of service from the sheriff. You're going to get something from the sheriff's office once the person gets served, which is called a return of service. My recommendation, if you get the return of service, is for you to file it with the court to let the court know, yes, this person has been served, so that person has knowledge of the pretrial conference, that we both have to show up. The rule in the pretrial conference is that if the person showing up has to show up with authority to settle without any further consultation. If you're an employee for a company, if you're a business owner, say, I want to send my manager to represent the company in the small claims matter, you can do so. But please know you're representing to the court that this manager has the authority to settle without asking, any consultations from you. The same thing that if you send an attorney to represent you in a small claims matter, and that's fine. We represent matters, in some cases, small claims as well. You're sending an attorney with authority to settle without further consultation. And the reason this is important is because when you go into the front of the court, you have a mandatory mediation conference with a county court mediator. Mediations takes about 45 minutes to an hour. They're not long mediations. So, and this is mandatory. It is free, meaning that it's included as part of your filing fee. You do not have to pay any additional money for the mediator. And the objective of the mediation is to see if this can get resolved. Let's put it in perspective. It's a $8,000 claim. Yes, it is a large amount of money, but in the context of civil litigation or business litigation, it is not a lot, because a business litigation will cost you, even for a smaller claim, it could cost you more than that based on the hourly fees and the amount of time that we have to do and prepare for trial. So you got to put that in perspective. But the important thing is that you have to show up, and whoever you're suing has to show up to this pretrial conference. A question that you probably ask, well, is this via Zoom or is this going to be in person? In some cases, it could be via Zoom. And I've done both. I've done the pretrial conference via Zoom, and it's up to the judge's preference, or it is in person. So, but you'll have the instructions on the pretrial conference. It will tell you if it is via Zoom or if it is in person. The important thing is you have to show up. If you do not show up for your case, the case could get dismissed. And a question that you may have, well, what happens if the person that I'm suing does not show up? Okay, that's a very good question. So the person does not show up to the pretrial conference, and the person has been properly served. The person did not call the judge to see if he can get rescheduled or file a motion to continue the pretrial conference. There was no communication with this defendant. Then the judge most likely will enter a default final judgment right there and then, and you won the case. That's what would happen. That's why if you have any claim that is in the $8,000 range for, say, $500, it might be worth giving it a shot for two reasons. Number one, the person doesn't show up, you won the case. Okay. Number two, the person shows up, there's a likelihood that the matter will get settled there and then. Sometimes it gets settled before, because you're going to go in a mediation conference, and we talked a few episodes back, what is a mediation? This case, if it's a mediation via Zoom, the mediator will get you guys in a separate room, you and the other party in a separate room, and then a virtual room, and then try to get the matter resolved. In my experience, in county court mediation, there's a really good chance this will get settled. So you're looking for $8,000. Very likely you're not going to get the $8,000 on mediation, but you probably get something, whatever you decide to agree with the other party, that is an amount that you're willing to walk away and accept and move on. Remember, before you had a piece of paper that the money's owed to you. If you took no action, you get nothing. That's guaranteed. By taking some action, there's a likelihood that you might get something in return. So let's assume that you agree to settle for $6,500. So what will happen in this case is the mediator will notify the judge, Judge, we have a settlement. The judge will then call both of you and verify the terms of the settlement. And then the court will enter a stipulation of settlement, which becomes an order. This is very important, because by having the stipulation signed by the court, if that individual does not pay you the $6,500, whether it's lump sum or in payments or whatever terms you agree to with the other party, okay, that person is in violation of the court order. You can go back to the court and ask the court to enforce the stipulation for settlement. And there might be some additional penalties to that. So small claims is a good vehicle mechanism to at least try to collect some money that is owed to you without risking a great deal of money. Can you do it yourself? The answer is yes. Can an attorney help you? Yes, but clearly it will be more expensive. The attorney's work will be the same, whether it's an $8,000 claim or a $50,000, $100,000 claim. Are the rules of court, and there's some variation with the rules of small claims, but what we're expected to do does not change. But it's a mechanism that you can exercise, and this is the only time that I'll tell you this you can do yourself. Now, what happens if you go to, you show up to the mediation and there's an impasse, meaning that you do not agree. This person does not want to pay you any money, or whatever they offer to you is an amount that is just not acceptable to you. That's fine. What will happen in this case is that the mediator will go to the judge and say, Judge, there's no settlement. We did not agree in terms. So the judge will say, okay, we're going to set this up for trial. And the judge will ask, how much time do you need for trial? How many witnesses? And you might have one or two witnesses. This time I have one or two witnesses. And then the judge will set a trial, usually within 60 days from that date. And then you have 60 days to prepare for trial. And it depends how much preparation do you need. If you have witnesses, you have to issue subpoenas. In that particular case, if you're in a situation that you might have to go to trial, it's good to, at the very least, consult with an attorney. Because trial preparation is very tricky. It is very complex. And if you're in a situation that there's an attorney on the other side defending the lawsuit and you're suing this individual, you might have to get an attorney to level the playing field. The reality of the situation, even in small claims, if you have an attorney being represented by one party and the other party is not represented by an attorney, the party with attorney representation has a competitive edge. And there'll be a winner, there'll be a loser. Because attorneys understand the rules of court and they understand what to do. And unfortunately, if you don't do this for a living, you don't. So at least I want to leave you with that. And obviously, I think in the next episode, I'll talk about if you have to try a case in small claims, what to do. And I'm probably going to do that one in the next week and give you some pointers. But up to the filing the statement of claim, getting to the mediation, getting to preliminary hearing, that is something you can do yourself. You do not need an attorney, only in small claims. I hope this information was helpful to you. Again, if you want to reach me and with any questions or comments, any questions you might have regarding any topics that we cover here in the podcast, please send me an email at richsierra.com. You want to learn more about our legal services that we offer. Our website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. If you want to watch the video of this podcast, we're at youtube.com/@RichardSierra. We're on X at Rich_Sierra. Instagram, FSB Legal. If you want to give us a call, make an appointment, learn more about us, our number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you like the podcast, please appreciate a 5-star review. Follow us as well and share it with your friends. That helps the algorithm to share this with other business owners that might be benefit from this information. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.